colleagues, and arbitration enthusiasts. Good morning, afternoon, or evening, depending on where you are. Welcome to the Turkish Arbitration Academy's webinar channel. As I'm sure most of you know by now, the Turkish Arbitration Academy is an initiative that has the aim of developing arbitration in Turkey by conducting qualified scientific research in the field of arbitration and dispute resolution more generally, with the engagement of established practitioners and researchers, principally through conducting various types of training, organizing events, webinars, national and international symposiums, conferences, and workshops, with the ultimate desire of enhancing national and international cooperation in the field. As most of you already know, by now we have dedicated the series to the examination of arbitration laws of major arbitral jurisdictions. Singapore is certainly one such jurisdiction. As such, today we will be conducting a deep dive into Singapore's laws and practices relating to arbitration, with a focus on the year past, that is 2023. We are fortunate to be joined today by Samantha Tan, Yong and Desmond Chong, all from Freshfields, Singapore. Samantha is a partner in Freshfields International Arbitration Practice Group. She is based in Singapore and has also spent time in Freshfields, Tokyo, and New York offices. Samantha's practice includes representing states and investors in investment treaty arbitrations, as well as international commercial and construction arbitrations. Yong is counsel in Freshfields International Arbitration Practice Group. He acts in international commercial and investor state arbitrations and advises on complex cross-border litigation. He is fellow of the Chartered Institute of Arbitrators and is also based in Singapore. Desmond is an associate in Freshfields International Arbitration Practice Group. He is dual qualified in Singapore and New York and was educated at Cambridge and Harvard law schools. Desmond has experience in both arbitration and litigation and previously served in the Singapore judiciary and as a prosecutor prior to joining Freshfields. Now, I wish to remind the audience that we will accept questions at the end of the presentations. So please do populate our chat box with questions, which I will raise at the end along with some of my own. Finally, a reminder that this webinar will be recorded and made available on YouTube in case you need to duck out and rewatch later, or would like to recommend that others watch it. And please do. Without further ado, I now pass on the mic to our panelists. Team, the floor is yours.
Thank you. Good afternoon, everybody. My name is Samantha Tan. My colleagues Yong and Desmond and I are delighted to be with you today. I understand that in the months and weeks past, you have been undertaking a comparative review of arbitration law and practice across various different jurisdictions. We would look forward to having this discussion with you today about the Singapore position, and to the extent you identify interesting differences between the Singapore view and those of your jurisdictions, we would invite you to share your views in the comment boxes. We would love to have a discussion with you at the end of today's session. I turn to slide 3, which sets out an outline for today's presentation. My colleague Desmond will start with an introduction to arbitration in Singapore. He will then continue to share with you some general developments in the law in Singapore that have an impact on international arbitration. The three of us will then spend the most time on item 3, where we'll go through some highlights from recent cases in Singapore. With that brief introduction, I would like to introduce my colleague Desmond to take us through the introduction. Desmond.
Thanks very much, Sam. Hello, everyone. I'm very happy to be here to share our insights on Singapore arbitration law and practice. As this is the first presentation in this series on Singapore, I will begin our sharing by setting out the broader context to Singapore as an arbitration hub and Singapore's arbitration legal framework and recent general developments. I first begin with some facts and statistics of Singapore's status as an arbitration hub. In this respect, it is truly very exciting to be practicing arbitration here in Singapore because the legal framework arbitral community, and institutions are all extremely conducive in facilitating the effective and efficient resolutions of arbitrations. As seen here, according to the 2021 Queen Mary University International Arbitration Survey, respondents were asked to identify up to 5 of their most preferred seats, and Singapore tied as the top most preferred arbitral seat in the world. Singapore is also among the top 5 most preferred seats in all the regions in the world. What is striking is the significant percentage gains that Singapore made as compared to the previous surveys that were done in 2018 and 2015. In this 2021 survey, for example, Singapore was chosen by 54% of respondents. In 2018, Singapore was selected by only 39% of respondents and was the 3rd most frequently chosen seat. And in 2015, Singapore came in 4th, chosen by 19% of respondents. So there has been a significant and steady increase in Singapore's popularity as an arbitral seat in the world. Next, respondents were also asked to identify up to 5 preferred arbitral institutions. And the Singapore International Arbitration Centre was the 2nd most preferred institution in the world behind the ICC. I next turn to highlight some key findings from the Singapore International Arbitration Centre's annual report last year. The SIAC commenced operations in 1991, and last year, the SIAC recorded its 2nd highest ever caseload of 663 new filings, 93% of which were international in nature, compared to 88% in 2022. The highest ever on record, according to the SIAC's reports, was in 2020, when there were 1,080 new filings, though this was due to a large number of interrelated cases. SIAC also saw its 2nd highest total sum in dispute last year of close to $12 billion US. The geographical spread of SIAC's arbitrator appointments have also increased, with arbitrators from 38 jurisdictions appointed last year, and increased from 36 jurisdictions in 2022. In 2023, the SIAC also handled cases involving parties from the highest number of jurisdictions ever, as parties from 66 jurisdictions chose to arbitrate at the SIAC. China, India, and the USA remained amongst the top foreign users, while the remaining top 10 users included parties from the UAE, Malaysia, Indonesia, South Korea, Thailand, France, and the UK. So as you can see from these statistics, it is quite exciting to be practicing arbitration here in Singapore. Now that I have set the background context of Singapore's broader arbitration scene, I want to delve slightly deeper into Singapore's arbitration legal framework. First, Singapore has adopted the Arbitral Model Law on International Commercial Arbitration. Thus, Singapore's arbitration law is very familiar and consistent with many jurisdictions in the world. I must note as well that Singapore adopted the model law with minor modifications through the International Arbitration Act. There are 4 key differences that I can highlight. The first is that the International Arbitration Act in Singapore allows parties to appeal to the Singapore courts against an arbitral tribunal's jurisdictional decision that it does not have jurisdiction, or the model law does not allow or envision such appeals on negative jurisdictional decisions by a tribunal. Second, the International Arbitration Act also allows the Singapore court to set aside an award on 2 additional grounds that are not provided under the model law. First, if the making of an award was induced or affected by fraud or corruption. And second, if a breach of the rules of natural justice occurred in connection with the making of the award, by which the parties' rights were prejudiced. And as will be shown later by Sam, a lot of litigation often revolve around whether a breach of the rules of natural justice occurred in the making of an award. Third, emergency arbitration awards are expressly enforceable under the International Arbitration Act, while the model law is silent on emergency arbitrators. Fourth, under the Singapore International Arbitration Act, the Singapore court may grant interim measures only if the arbitral tribunal or arbitral institution has no power or is unable for the time being to act effectively. On the other hand, under the model law, a court shall have the same power of issuing an interim measure as a tribunal. Therefore, for international arbitrations in Singapore, interim relief should first be sought from the tribunal rather than court. Next, there is a dual regime for arbitration in Singapore because there are two statutes that govern the procedural framework for arbitrations in Singapore: the International Arbitration Act and the Arbitration Act. The Arbitration Act governs domestic arbitrations or non-international arbitrations, while the International Arbitration Act governs international arbitrations, or if the parties agree in writing that the International Arbitration Act or the UNCITRAL model law is to apply. Third, an important point to highlight about Singapore's legal framework is that court-related proceedings are heard in private or are heard confidentially by default. And this is provided for by legislation under both the International Arbitration Act and the Arbitration Act. This is a relatively unique point about Singapore because it is not uniform globally that court proceedings relating to arbitration are confidential by default. Fourth, court proceedings relating to international arbitrations in Singapore are often funneled to the Singapore International Commercial Court to decide. Therefore, this means that the cases will be heard by judges, international judges, from all over the world, and they are in a separate docket from the pending domestic Singapore case. I next turn to two significant general developments that have occurred in Singapore recently. The first major reform that happened is the introduction of conditional fee arrangements in Singapore. With effect from the 4th of May in 2022, conditional fee arrangements are permitted in Singapore for arbitration proceedings and related court and mediation proceedings. What are conditional fee arrangements? These are agreements where a lawyer receives payment of a part or all of his legal fees in specified circumstances. For instance, if a client's claim is successful. Such a CFA agreement may take the form of, for instance, a win more fees kind of situation. And this is what is referred to as an uplift fee, which can be in a gross sum or an hourly rate. A CFA agreement can also take the form of a no-win, no-fees type of arrangement, or it may take the form of a no-win, less fees type of agreement. To be clear, a conditional fee arrangement is not the same as a contingency fee agreement. What this means is that a conditional fee arrangement cannot provide that the lawyer may share in an agreed percentage of the sum recovered by the client with no direct correlation to the work done. This is different from some other jurisdictions, such as England and Wales, Australia, and Hong Kong. A CFA also cannot provide that the lawyer will not be liable for negligence or will be relieved from any responsibility to which the lawyer would otherwise be subject as a lawyer. Finally, the SIAC model clause was revised last year as of 12 January 2023. There is one new feature worth noting about this model clause, and that is that it now provides an option of choosing the Singapore International Commercial Court as the supervisory court of the arbitration, as shown in bold in this slide. Other notable features about the SIAC model clause are that First, the seat of arbitration can be edited, so parties do not have to choose Singapore as the legal seat of the arbitration. And indeed, from our experience, it is not uncommon for arbitrations to be seated in other jurisdictions other than Singapore, but where the SIAC is the administering institution and the relevant arbitral rules that govern the arbitration are the SIAC rules. Furthermore, the model clause provides a general choice of law clause for the main commercial contract, instead of a specific choice of law clause for the arbitration agreement. So parties may want to consider specifying the law governing the arbitration agreement. Yong will share a bit more about a recent case in Singapore that touches quite importantly on the choice of law regarding the arbitration agreement. Now that I have finished setting out the broader context to Singapore's arbitration framework and theme, I will hand over to Yong to talk about some of the more notable highlights from Singapore's recent cases. Yong.
Thanks, Desmond, and hi, everyone. In this section of the presentation, we will cover several developments in Singapore case law concerning arbitration from 2023. You'll see on the screen that these are broken down into three themes: intersection between the arbitration regime and the insolvency regime in Singapore, followed by general arbitration issues, and in particular, we will focus on issues of confidentiality and on arbitrability. After I cover these two topics, Samantha will then talk about recent developments in case law concerning setting aside and enforcement. So on to the first theme, intersection between arbitration and insolvency. Now, just to start things off, as you may or may not know, the general approach that is adopted in insolvency is this: when you have a company that has a debt owed to someone, that person can petition for the winding up of that company if that person can establish that the company is insolvent. And there are several tests that the law will apply to determine whether the petitioner has made out a prima facie case that the company is insolvent. The one way the company can resist this petition would be if the company can establish that the debt is a disputed debt. In other words, there is some question over whether the debt is even valid, over whether these sums are even owed by the company to the party petitioning for the winding up of the company. And so you see on the screen here that the first question, and I'm looking at the top of the screen, the first question that the court will consider is whether the debt is disputed on bona fide and substantial grounds. And if you go down to the left, if the debt is disputed, the court will ordinarily dismiss the application, because in the insolvency context, the role of the court is not to rule on whether the debt is a valid debt, whether the claim is a valid claim. That is a matter for litigation or even arbitration. The role of the insolvency court is only to deal with debts that are bona fide debts, that are actual debts that have already been established. And so if you look on the right side of the screen, that is what happens when the debt is not disputed. Then the claimant would have succeeded in establishing that it is a creditor of the defendant. And then if you look down, the court will either go on to establish whether the company should be wound up, that's the box on the left, or if the court, for whatever reason, determines that it is inappropriate to move to consider winding up at this stage, if let's say there are some other outstanding issues that need to be resolved by way of litigation, then the court might direct the parties to deal with those issues by litigation on arbitration first, before the question of winding up is considered. So this is how things are normally approached in Singapore concerning the winding up of a company on the basis of a debt. The tricky question, or one tricky question arises where there is an arbitration agreement underlying the debt in question. So, for example, if one party is asserting that a debt is owed under a contract, say I sold you some widgets and you owe me the purchase price for those widgets, and the contract for the sale of those widgets has an arbitration clause, then the court would then have to consider whether the matter should be dealt with by arbitration first before the insolvency regime kicks in. And what you see on the screen is the typical approach that the Singapore courts will adopt in deciding whether to refer the matter to arbitration or to proceed with the insolvency process. You'll see on the left that the court will dismiss or stay the winding up proceedings if all of the following requirements are met on a prima facie standard. So if the court is persuaded on a prima facie basis that there is a valid arbitration agreement between the parties, and that the dispute concerning the debt falls within the scope of that valid arbitration agreement, and the dispute, and this is an important factor, the dispute is not being raised by the debtor in abuse of the court's process, then the court will dismiss or stay the winding up proceedings, because there is a genuine dispute here. And so the appropriate mechanism is not the insolvency process. The appropriate mechanism is the arbitration agreement that the parties have entered into. This point here about the dispute not being raised by the debtor in abuse of the court's process is something that there's been a lot of litigation around, because the question is, what constitutes an abuse of the court's process? Some examples that we have seen have been where the court is persuaded that there is no genuine dispute, that this is a dispute that has been contrived by the debtor in order to avoid being dragged into the insolvency process. So, for example, if the debtor previously admitted that this debt did exist, but then subsequently changed his position, that might be evidence of the debtor, raising the dispute only as an attempt to abuse the court's process. If you look on the right side of the screen, there is another situation in which the court may not decide to dismiss the winding up proceedings. And that is where the creditor can demonstrate that there are legitimate concerns about the solvency of the company as a going concern. So even if there is a genuine dispute around the debt, if the fact of the matter is that the company's financial position is problematic, if the company's financial position does appear to be insolvent, then the court might decide that instead of dismissing the winding up application, which would put an end to the entire process, the court may instead decide to impose a stay, in other words, a temporary pause on the winding up process while the debt is dealt with in arbitration. The other box you see on the right-hand side of the screen is where the debtor has not raised any tribal issues. In other words, where it is clear that there is no dispute at all around the debt. And in that case, then one might argue that that the issue does not even fall within the arbitration agreement, and therefore there is no need to dismiss the winding up proceedings. Now, this approach, however, does not apply in the context of a judicial management application. The difference between a winding up proceeding and a judicial management application is this. In a winding up proceeding, the aim is to wind up the company's affairs, ensure that its creditors are paid off to the extent possible, and it normally culminates in the end of the company. In the judicial management application, the objectives are quite different. The objective is to rescue and rehabilitate an ailing business. And because we have that objective in play, the interests that the court looks at are not limited to the interests of the debtor and the creditors of the company. The court also looks at broader public interests that might be engaged by the survival or the rehabilitation of the company. And because of this different objective in judicial management, there is also a different criteria that needs to be applied. So for example, the court needs to be satisfied that one or more of the statutory purposes behind judicial management is engaged. It is not as simple as a creditor presenting a winding up petition. The court's own discretion and own judgment needs to come into play before a judicial management application is granted. And so because of these factors, the Singapore High Court has held that the approach I just described does not apply in the context of judicial management. That where there is a judicial management application, the court should not limit its discretion to either staying or dismissing the application where there is a dispute alleged around the debts in question. Instead, the High Court has said that the court needs to make a more holistic assessment of the facts and consider the interests of other stakeholders of the debtor company and the wider public interests. This is significant because this means the court will look at other parties who may not be party to the arbitration agreement and look at other factors that the court would not normally look at if this was in the context of a simple winding up petition. If we then move on to the next section on general arbitration issues, another issue that has been that has come under consideration in 2023 by the Singapore courts is the issue of confidentiality, and this applies on two fronts: confidentiality of court proceedings relating to arbitration and confidentiality of tribunal deliberations. And you see on the left-hand side of the screen that there is a Singapore Court of Appeal case, Republic of India and Deutsche Telekom, which sets out when confidentiality of court proceedings can be lost. Now, the default position is that arbitration-related court proceedings are to be heard in private, that they are to be confidential. And that makes sense because if the underlying arbitration is confidential, you would undermine that confidentiality if related court proceedings are not protected by confidentiality. And so all of the gory details surrounding the arbitration can be heard in open court. However, and you see that's the second bullet point here, where the confidentiality of the arbitration has been lost, then the court is not going to be too eager to try to impose confidentiality on the related court proceedings anyway, because the countervailing factor at play here is the principle of open justice. The idea that as far as possible, justice should be public, justice should be done openly. So in this case of Republic of India and Deutsche Telekom, what happened was that confidentiality was lost, and you'll see in the next slide exactly how it was lost. And as a result of that, the Court of Appeal dismissed the application for the enforcement proceedings to be heard in private. If we could just go back one slide then to the other sort of concept of confidentiality that was discussed in recent case law. This is quite different. This is about the confidentiality of tribunal deliberations. So in other words, the confidentiality of discussions between tribunal members as they attempt to reach a decision on how to rule on the dispute before them in the arbitration. And in this context, the Singapore court came out quite strongly and said that these deliberations are to be protected. They are to be considered confidential. There was a bit of a nuance to that ruling because the court said that this protection of confidentiality does not apply where the challenge is to what may be described as the essential process of the deliberations rather than the substance of the deliberations. Now, the court didn't go into a great amount of detail concerning exactly when you would be able to tell that the challenge applies to the essential process rather than to the substance. But the fact is that it did leave the door open to someone arguing in future that because their challenge is to the essential process, such as, for example, the impartiality of the arbitrators, confidentiality of their deliberations should be lifted. If we could now move on to the next slide, which you would have seen earlier. Now, this slide sets out what happened in this particular case of Republic of India and Deutsche Telekom, and how it was that in this case, confidentiality of the arbitration was lost. And you'll see that what happened was that awards were published on third-party sites. Global Arbitration Review, which is one of the leading arbitration-related publications, had also published an article disclosing certain confidential information about the proceedings. There was a LinkedIn post and other information that also entered the public domain. And so I think that the long and short of this, or maybe the moral of this story, is that you should not assume that as long as your court proceeding relates to arbitration, that proceeding will always be protected by confidentiality. One thing you have to ask yourself is whether the underlying arbitration has lost its element of confidentiality. Because if so, then the court proceedings, at least in Singapore, may not be so easily protected by confidentiality. The next topic and the last topic I'll touch on today concerns the choice of law to determine arbitrability. In other words, when a tribunal or when a court has to decide whether an issue or a particular claim is arbitrable, whether it's something that can be dealt with by way of arbitration, what law should govern that decision? And this was a question that was ruled on again quite recently by the Singapore Court of Appeal in Anupam Mittal and Westbridge Ventures. The question in this case concerned whether certain company law-related issues relating to minority oppression of shareholders, whether those issues were arbitrable or whether they were subject to the jurisdiction of an Indian body known as the NCLT. And what the Singapore Court of Appeal said in this case is that there's a sort of two-stage test that applies. In the first instance, you need to look at the law governing the arbitration agreement. And you need to ask yourself whether this particular claim, this particular issue, is something that the law governing the arbitration agreement considers arbitrable. As you may know, under certain laws, certain matters are not considered arbitrable. Under certain laws, matters involving issues of criminality or matters involving issues of divorce or child custody may not be considered arbitrable, whereas under other types of laws, they may be. And so the Court of Appeal said the first thing you look at is, what does the law governing the arbitration agreement say about this? Does this law treat this issue as arbitrable? But we don't stop there, because the second stage of the inquiry is whether the law of the seat considers that dispute to be arbitrable. And this arises out of one of the grounds for setting aside awards, which is where the issue that is the subject of the award is considered to be non-arbitrable under the law of the seat. Therefore, if there is an issue that is arbitrable under the law governing the arbitration agreement, but is not arbitrable under the law of the seat of the arbitration, then that issue would not be considered arbitrable in the context of that particular arbitration. And so this composite approach was something that was introduced quite recently by the Court of Appeal in this particular case, and it has invited a lot of controversy. If we could move on to the next slide, you'll see a breakdown of the Court of Appeal's reasoning in this context. And the one thing I want to call out is that the court's reasoning was very much guided by the idea that when you ask yourself whether a matter is arbitrable, the principal question is one of public policy, because public policy tends to be the guiding factor in determining whether something like, say, child custody or issues of divorce should be dealt with in a private forum like arbitration instead of the courts. And what the Court of Appeal said in this case is that when you think about public policy, you should not only focus on the public policy of the seat of the forum, you also need to take into account relevant foreign public policy. And one of the ways in which you would do that is asking yourself, what is the public policy of the law governing the arbitration agreement? Because that should play a role in determining whether a dispute is arbitrable. So that, and if you go on to the next slide, you'll see that there are other alternative approaches that the court considered in deciding, what law should determine whether a matter is arbitrable. And I'll leave you to read that for yourself. But I think the takeaway here is that the court finally landed on a composite approach that takes into account both the law of the arbitration agreement and the law of the seat. And with that, I'll pass you over to Samantha, who will touch on the third set of topics that have been covered in recent case law in Singapore.
Thank you. Hello again, everyone. In this final section, I will discuss 4 cases that have come up recently before the Singapore courts in the context of applications to set aside arbitral awards and to enforce arbitral awards. 3 of the cases are setting aside decisions. You see the blue coloring on the cover sheet demonstrating that I'll talk about setting aside first. And the 4th case is on enforcement. Over to the next slide is the first setting aside decision. The first thing to note is there have been a number of, quite a lot of, in fact, applications before the Singapore courts attempting to set aside arbitral awards on the ground of breach of natural justice. Recall that Desmond introduced the Singapore arbitration regime at the beginning of this presentation, and he told you all that there are 2 grounds that are unique to Singapore's arbitration law. One of them is the ability to apply to set aside an arbitral award on the ground of breach of natural justice. Perhaps unsurprisingly, many parties have applied to the courts to try to set aside awards on this ground. It's possibly the most common ground on which set-aside applications are made in Singapore. They're always coupled with one of the model law grounds, but the breach of natural justice ground is one that has been relied on significantly. The first 2 cases, this one and the next one that I'll talk about, are both cases where perhaps more uniquely, the courts did agree to set aside at least part of an award on the basis of breach of natural justice. This case, I know I was supposed to talk about cases in the year past, but it's actually from 2022, but it's important context for the 3rd case that I come on to talk about. In this case, the Court of Appeal set aside an award in part, so not the whole award, just the damages order that was at the end of the award. And the basis of this partial set aside is set out in item number 3 on the slide. It is that the tribunal's chain of reasoning that led to the damages order was not one which the parties had reasonable notice that the tribunal could adopt. Further, that chain of reasoning did not have a sufficient nexus to the arguments that the parties made in the arbitration. This is an important finding, both of them are, because subsequent applications for set-aside on the breach of natural justice ground have tried to use the same phrasing to argue that the chain of reasoning in those cases also was not one in which the parties had reasonable notice, nor did it have a sufficient nexus to the parties' arguments. But the other point that I want to call out from this case is that the parties, or the claimant in this case, tried to argue that the award should be set aside on the basis of what is called the no evidence rule, and that's set out at the top of the slide, which is an argument that the court may set aside an award containing findings of fact that were made with no evidential basis, and that this would fall within the grounds of breach of natural justice. The Singapore court, and this is in the box number 1, held that the no evidence rule should not be adopted as part of Singapore law, as it would contravene the policy of minimal curial intervention in arbitral proceedings. So an interesting decision, and we can see similar lines of argument being raised in other cases. The next slide shows also a case from 2022. Sorry, not the next slide, but the next one. BZW and BZV, in which in the outcome box, you see the Court of Appeal upheld the lower court's decision to set aside an arbitral award, again for breach of natural justice, and affirmed the decision below not to remit the award to the tribunal. This case was interesting, at least to me, because the court actually recognized that it could be possible to set aside a decision on the grounds that the tribunal came to a manifestly incoherent decision. That's the third bullet point on the slide. In this case, the court rejected the appellant's argument that a tribunal can be manifestly incoherent in making its decision and still have its award stand. But it's important for us to understand what the court meant by manifestly incoherent. The next sentence explains this. A manifestly incoherent decision shows that a tribunal had not understood or dealt with the case at all, which would mean that the parties had not been accorded a fair hearing. So strictly speaking, the basis of the set-aside decision in this case, which was the breach of the rule of natural justice, was that the fair hearing rule had been breached. The court found that in point number 1, the tribunal failed to apply its mind to the essential issues arising from the parties' arguments. And second, and this is going to sound familiar to you, there was an absence of a sufficient nexus between the tribunal's chain of reasoning and the parties' arguments. So it's possible in Singapore for awards to be set aside by the Singapore court. The Singapore courts are scrutinizing awards quite closely, but I have to say, for the avoidance of confusion, that this case and the one that I dealt with just before are exceptions. By and large, most applications for set aside get rejected by the Singapore courts. And that brings me to one example of that. Excuse me. The next slide, CVV and CWB, is a case from 2023 in which the court refused to set aside an arbitral award on the basis of breach of natural justice, even though the parties tried pretty much the same arguments, that there was a lack of nexus to the parties' arguments, and that the tribunal did not give the parties reasonable notice of the chain of reasoning it was going to adopt. This case, though, dealt with one particular aspect of the parties' arguments that are different from the ones that were dealt with in the cases before. In point number 1 on this slide, we show you that the Court of Appeal commented in obiter that while the tribunal has a general duty to give reasons, and this is required under the model law, it's not settled in the case law whether a tribunal's failure to give adequate reasons is itself a reason to set aside an award. So it's clear that a tribunal has a duty to give reasons, but the Singapore Court of Appeal said that even if a tribunal has failed to give adequate reasons in its award, that may not be a reason to set aside an award. It's also not clear from the court's decision whether the court will find if a tribunal gave no reasons at all, that to be a reason to set aside an award. There are arguments to be made. So in the event, the court did not have to make a pronouncement on this issue because, and you see this in item 4, the claimant's case ultimately for setting aside the award was premised on breach of the rules of natural justice rather than the tribunal's failure to give reasons in and of itself. The argument made by the claimants was essentially that because the tribunal had failed to give reasons on certain issues or certain decisions that it had made, that suggested that the tribunal had not applied its mind to those arguments. In the event, the court found that this was an argument based on breach of natural justice rather than the failure to give reasons in and of itself. And so on the basis of the breach of rules of natural justice, the argument on that breach, the court found that the claimant's case could not stand. This brings me to the last case that I'll cover, which is on enforcement. The case in question is India and Deutsche Telekom. The case names might sound familiar to you. It's the same case, or it arises from the same case that Yong discussed earlier about confidentiality. This was an application by the Republic of India challenging the enforcement of an investor state arbitral award that Deutsche Telekom had obtained. The seat court, which was in Switzerland, already dismissed India's arguments challenging the award. In particular, India argued that the tribunal had no jurisdiction in the underlying arbitration because there was no qualifying investment. The Swiss courts dismissed that argument, but India tried the argument again before the Singapore courts at the enforcement stage. And the Singapore court gave pronouncements on two principles that are particularly interesting and that we want to highlight to you. The first is this: the transnational issue estoppel principle. The court found that it is appropriate for a Singapore enforcement court to apply this doctrine when determining whether preclusive effect should be accorded to a prior seat court's decision going towards the validity of an arbitral award. There are, of course, some requirements, sometimes pretty difficult requirements to satisfy transnational issue estoppel. For example, the specific issue in question must have been discussed before the seat court. But if these requirements are satisfied, it's possible for there to be preclusive effect from the prior seat court's decision. And the second principle that the Court of Appeal accepted was that where the transnational issue estoppel doctrine does not apply, an enforcement court in Singapore should still accord primacy to a prior decision of the seat court when enforcing an arbitral award. So this is helpful to parties because they don't have to make arguments before the seat court and before various enforcement courts, including Singapore's, over and over again. The Singapore courts will take recognition of what's been decided and argued before the seat court. This takes me to the end of our presentation on recent cases in Singapore, and that leads me to invite Doğan back for a quick discussion among all of us.
Thank you very much, Samantha, and thank you very much all. That was an excellent presentation, if I may say so. And I am sure the audience will echo that sentiment. As a personal remark, I think the cases demonstrate why Singapore is such an attractive and popular seat of arbitration. The cases discussed were very much arbitration friendly, and it seemed that the judges knew what they were talking about. I in particular liked the deferential approach that the Singaporean courts took in the Republic of India and Deutsche Telekom in respect of the transnational issues double. So that's all very encouraging and good to see. I would like to, as I said, ask a couple of questions of my own before I open the floor, the virtual floor, albeit to questions from the audience. So my first question is to you, Sam, given you were the last to speak. So you will be rewarded with the first question. As a non-Asian practitioner, I always get asked whether the client should opt for Hong Kong or Singapore as a seat of arbitration when those are the options being considered. Now, in a truly non-partisan way, what would you say the advantages of arbitration in Singapore are as compared to Hong Kong, both institutionally and also in respect of the kind of legislative framework and the judicial approach and attitude towards arbitration? How would you compare those two jurisdictions?
Thank you. It's a question, to be honest, that we get asked very often and increasingly so. I think I would say that at present, both Singapore and Hong Kong as seats of arbitration are perfectly sound. I haven't done the statistics comparison, but I imagine the volume of cases that are going before the Singapore courts in set-aside applications or enforcement applications or other applications for support of the arbitration, perhaps at the interim stage, is likely to be growing rapidly. It has been already and will be in the coming years. What that means is the Singapore courts are going to have the opportunity to issue judgments with their reasoning, their thinking on very pertinent issues that arise in international arbitration cases. And that body of jurisprudence, just as demonstrated by all the cases we covered just now, is just going to be growing more and more and more. And that makes Singapore a very attractive seat jurisdiction because you have more and more transparency as to how the Singapore courts are likely to decide particular issues that might come up. Frankly, I haven't done a similar analysis of the Hong Kong jurisprudence. There have in recent years been very sound cases handed down by the Hong Kong courts on very similar issues to those arising in Singapore. For example, as I understand it, there is a recent Hong Kong court decision pronouncing on the interplay between insolvency disputes and arbitration, and the outcome was very similar to what the Singapore courts have come up with. So at the moment, really very sound jurisprudence from both jurisdictions, and so very favorable choices of seat. You asked about the institutions as well and comparing those. I think there's going to be a difference, and probably already is, in the kinds of cases that each institution is administering and is getting experience administering. The cases in Singapore come from China, Hong Kong, US, and India as the top users. And so the kinds of cases that the SIAC is going to get very familiar with administering are cases that are coming from these jurisdictions and others in Asia, I should say. It's quite a diverse mix of jurisdictions whose parties are using SIAC arbitration. As for HKIAC, I think there is a movement towards the cases administered by the HKIAC being more mainland China-centric. And that means that the institution is going to have increased familiarity and experience with dealing with parties from those jurisdictions. And so that's something to take into account when you choose the institution that you might want to have your arbitration heard in.
Perfect, thank you. My next question is to Yong Wei. Yong Wei, you mentioned that court proceedings relating to arbitration are confidential and will be heard in private by default. Now, how difficult is it to make and succeed on an application to lift that veil of secrecy? What are the considerations that the Singaporean courts usually take into account? And have you had a personal experience of such an application?
Thanks, Doğan. The short answer is very difficult because the protections of confidentiality for arbitration-related court proceedings are found in statute. They are not merely the product of case law that has evolved over time. As for how you would lift confidentiality, one example is the case that we discussed earlier on today's presentation, where you can show that the underlying arbitration has already lost its element of confidentiality. Apart from that, I would imagine that you would need to show some sort of overriding public interest element outweighing the need to protect the confidentiality of the parties. But I can't say I've had personal experience attempting to either lift or to resist the lifting of confidentiality, simply because it's so sacrosanct, at least in the context of Singapore law.
Thank you. And just while I have you on, there's a question from the audience on the case that you've just referenced, so the Republic of India and Deutsche Telekom AG.
Sure.
And as you mentioned, that there was a loss of confidentiality in that case, given what had happened, the LinkedIn post, etc. Do you think it was relevant in that case, as regards the approach taken by the court, that one of the parties was a state? And would, do you think, the Singaporean courts have taken the same approach in a dispute that, if it were, between truly commercial parties?
That's a really good question. Just thinking out loud, I think my answer would be no, that it would not have made a difference to the courts in that case, to the Singapore courts in that case, because the confidential nature of arbitration isn't something that is attenuated by whether the party participating in it is associated with a state or not. There was a separate discussion around whether arbitrations, especially investor-state arbitrations, involving states and involving challenges to state policy and state regulations should not be confidential because they involve elements of public interest. But I think that is probably a separate debate compared to what we're talking about here, which is very simply whether the default protection that exists under the Singapore International Arbitration Act, whether a different test applies depending on whether a party is a state or not. And I don't think that a different test does apply.
Okay, well, thank you. The final question, I think we are just 2 minutes under time, so we've got room for one more question, and that question is to you, Desmond. You explained that in Singapore, you have this dual legislative regime, i.e. you have a domestic law on arbitration and an international law. Have there ever been cases before the courts or that you've encountered where two related disputes were consolidated and heard together in the arbitration, a single award rendered, but then that award was attempted to be challenged? What do? Do you challenge that under the international legislation framework or under the domestic legislation? I know it's a very kind of narrow niche question, so you may not have encountered this issue, but what happens if you do have that kind of an issue? Which law applies?
Thanks, Doğan, for that question. That is an interesting question. I think generally it is quite clear which applicable statute or regime will apply, because both statutes make it clear that the Arbitration Act will only apply if the International Arbitration Act does not. And the International Arbitration Act also specifies in quite a lot of detail how it applies. So for example, it applies to an arbitration if it is international, and that is defined in detail in the statute as well. And the International Arbitration Act also applies if the parties agree in writing that it should apply, or if the UNCITRAL model law should apply. So in general, we don't usually encounter a situation where it is difficult or complicated to consider which statute applies. But in any event, both statutes are quite similar in their applicable procedural framework. There are a few key differences, but otherwise they are similar. So for example, under the Arbitration Act, parties have a limited right of appeal on questions of law. Under the Arbitration Act, parties have a limited right to apply to court to determine an issue of law. But otherwise, the two are quite similar in their regime.
Okay, well, thank you very much. I think we have completed the hour. So I think let's put a stop to it today. It only leaves me to thank you all, the panelists, for carving out your time in your busy schedules to deliver this webinar. It's very much appreciated. And I'm sure the audience is also as much appreciative of your efforts and delivery. So thank you very much. If the audience has any further questions, I'm sure they can reach out to you through your email, direct emails on, I'm sure it will be on your Freshfields profiles. So that's a cue for the audience in case they have any further questions or they have Singaporean law related issues which they would like to pick your brains on. But thank you very much. It's been a pleasure to have you on, and hopefully we'll have you on next year.